This Honorable Court of Tennessee is now in session.
All right. Thank you, Madam Clerk. Welcome, everyone. This is day 2 of the November docket of the Tennessee Court of Criminal Appeals here in Nashville. And I will introduce the panel: Judge Ross Dyer from Memphis, Tennessee, and Judge Jill Ayers from Clarksville, Tennessee. And my name is Robert Wiedemeyer. I'm the presiding judge for this panel. We are very much appreciative of the efforts by the AOC, including Nick Morgan, and also our clerk's office for arranging for these arguments to be heard in this fashion on Zoom. We are very anxious to get back into the courtroom and back to some normalcy. But in the meantime, this procedure has worked pretty well to get the oral arguments heard and the cases on our docket disposed of. So that being said, we conduct things on Zoom as close as possible to the way we conduct things in the courtroom. Each side has 20 minutes. It's my understanding that Mr. White, you've requested 3 minutes of rebuttal time, and so I'll try to help you keep up with your time when you get started. We have read your briefs, and so you can, if you want to tailor your arguments because we are familiar with your briefs, that's fine also. I think those are all the preliminary matters, and I'll ask Ms. Kraft to call the case, please.
Jerry Lewis Tuttle versus State of Tennessee.
All right, Mr. White, you may proceed.
Thank you, Your Honor, and may it please the court, Brandon White of the Murray County Bar, on behalf of the petitioner appellant, Mr. Tuttle, I would like to reserve 3 minutes for a rebuttal. Obviously, there's 8 issues raised in Mr. Tuttle's brief, and so if the court has any specific questions about any of those issues, I would certainly welcome those questions. But leading off with the very first issue, trial counsel was ineffective when he agreed to stipulate during the trial, essentially during an in-chambers meeting, that Mr. Tuttle was in fact a convicted felon. Of the 6 charges for which Mr. Tuttle actually stood trial, none of those charges required as an element of the offense any proof whatsoever that Mr. Tuttle was actually a convicted felon. Initially, there was an additional charge of Mr. Tuttle being a felon in possession of a firearm, and for whatever reason, the state elected to nollie that charge, I suppose, at some point prior to the trial. So he wasn't standing trial in any offense that required proof that he was in fact a convicted felon. And really the only reason that him being a convicted felon would even remotely matter in this case at all is the fact that he was charged with being or with possessing a firearm with the intent to go armed during the commission of or attempt to commit a dangerous felony. And under TCA 3917-1324 G2, that would matter for purposes of sentencing enhancement, but it would not matter for purposes of whether the jury, as the fact finder, would conclude that he was actually in possession of the firearm. So the only reason it possibly matters is sentencing enhancement. Nevertheless, trial counsel stipulated that he was in fact a convicted felon.
What was his prior conviction for?
Judge, he had multiple prior felony convictions. Unfortunately, they mirror some of the offenses for which he was convicted. In this case, conspiracy to distribute more than 300 grams or 300 pounds of marijuana, money laundering. Fortunately, I guess for him, the actual offenses were not told to the jury of what he was convicted of previously, but there was an acknowledgement through Lieutenant Doley's testimony that he was in fact a convicted felon. And there was a stipulation presented to the jury to that effect. So it's not as damning as it could have been, in the sense that the jury wasn't told that he was convicted of basically these same offenses from back in the early 2000s, but they were erroneously instructed that he was a convicted felon.
Well,
as far as
would his prior felonies been admissible for impeachment purposes?
I think they would have been admissible for impeachment purposes had he elected to testify, but he, of course, did not elect to testify, and so I don't think that they would have come in through that avenue.
Okay, and one other question. What exactly does the stipulations, how does it read?
I'm not aware off the top of my head exactly what the stipulation says. I know that my brief acknowledges Lieutenant Doley's testimony when Lieutenant Doley was asked on direct whether he was in fact, Mr. Tuttle was in fact a convicted felon, and the answer was yes, and no objection was lodged, and they kind of moved on. And perhaps I erroneously stated there was a stipulation. That is my recollection. It's a very voluminous record, but I know for a fact that Lieutenant Doley was asked that question in front of the jury, and he answered in the affirmative that Mr. Tuttle was a convicted felon, and so the jury was informed of that. As far as the person,
So then really the only thing you have based on what you're saying is one statement by a police officer in passing with no background as to what the felony was, how good, bad, similar, dissimilar. He's just a convicted felon. That's all we have in the record. Is that one statement?
I believe so, Judge, but I would respectfully submit that as far as the prejudice goes, I would submit that that's error, that the state is not even really contesting in its brief that's not error. But as far as the prejudice goes, this court took the incredibly rare step on direct appeal of reversing Mr. Tuttle's conspiracy convictions for insufficient evidence. And if I had $1 for every time that that's happened, I don't think I'd be a very wealthy person. And so given that the proof was so thin, at least as to some of the charges, especially the conspiracy charges, that this court reversed his convictions, the fact that the jury was apprised of him being a convicted felon at all would negatively impact his ability to receive a fair trial. I cite in my brief the Faust case, in which this court acknowledges that apprising the jury of a defendant's prior felony conviction is error in this instance when there's either a status offense or, in this instance, possessing a firearm with the intent to go armed during the commission of a dangerous felony. This court in Faust holds that that's reversible error. The U.S. Supreme Court in Old Chief, which traditionally is used for 403 analysis, also holds that apprising the jury of the fact that the defendant is a convicted felon is reversible error. And so while I would acknowledge that a big deal about it wasn't made during the trial, it was made a deal during the trial, or it was brought up during the trial by virtue of the fact that it was asked. It should have never been asked, and the jury should not have learned that he was a convicted felon. I would also, before moving on from this issue, note that the state relies on Griffin to support its position that this was not a prejudicial error. And Griffin does analyze Faust. And in Griffin, Judge Williams noted that although the preferred or better procedure is to bifurcate the proof, it's not mandated. And I would note with respect to that issue, number one, Griffin isn't reported. Number two, Griffin involved the defendant being charged with the offense of being a felon in possession of a firearm. And that would require proof as an element of the offense that the defendant was in fact a convicted felon. Whereas in this case, Mr. Tuttle is charged under a separate statute, 3917-1324, and under subsection F2, that statute specifically states that the mechanism or the procedure is to bifurcate the proof. And so even if in Faust and even if in Griffin, which relate to the charge of being a felon in possession of a firearm, even if that's the preferred procedure for those types of charges, and with this type of charge, the legislature takes the guesswork out of it and directs that the proof is supposed to be bifurcated, at least for sentencing enhancement purposes. I would also note in the Tennessee Supreme Court has held in State versus Rodriguez that the admission into evidence of unfairly prejudicial propensity evidence is more harmful in close cases. And obviously this was a very, very close case in terms of at least the conspiracy convictions. The next issue raised in the brief relates to whether conspiracy to possess a firearm during the commission of a dangerous felony constitutes a qualifying predicate dangerous felony under TCA 39-17-13-24. And the state argues with respect to this issue, first, it does note that it's an issue of statutory construction, but the state fails to explain how conspiracy to commit an offense is encompassed anywhere within that statute. We're all aware of the fact that conspiracy is a separate and distinct inchoate offense than attempt to commit an offense. And the state would argue to the court that because the statute basically encompasses selling or distributing a controlled substance, that somehow conspiracy to sell or distribute a controlled substance falls within the realm of the statute. That reading of the statute would unduly expand the reading of the statute because conspiracy is nowhere listed in the statute, number one. And number two, it ignores what conspiracy even contemplates. Actually selling and distributing a controlled substance constitutes actually committing the offense of selling or distributing the controlled substance, whereas conspiracy does not. One can be convicted of conspiracy wherein two or more co-conspirators agree to commit a crime and one or more of the co-conspirators take an overt act in furtherance of that conspiracy. So you don't actually have to commit the offense of selling the controlled substance or distributing the controlled substance to be convicted of conspiracy. And so the state makes no effort in its brief to explain that fact, that one can be convicted of conspiracy, but not actually sell the drug or not actually distribute the drug. And it also doesn't reference anything about the fact that conspiracy is nowhere listed in the statute. It basically just wants the court to think that because selling and distributing drugs constitutes a dangerous felony, or an attempt to do one of those things constitutes a dangerous felony, that somehow conspiracy falls in line as well. And it simply doesn't as a matter of statutory construction. That relates to more than one issue in the brief. Number one, that trial counsel was ineffective in failing to challenge that, as well as the fact that it's a void conviction, because if conspiracy to sell greater than 300 pounds of marijuana is not a qualifying predicate felony, then Mr. Tuttle's conviction for possessing a firearm during the commission of that allegedly dangerous felony is void, because the indictment fails to state an offense as to that charge. Trial counsel was also deficient in failing to object to the jury instruction for the firearm offense. The jury instruction that was provided to the jury erroneously included three mens rea options: intentionally, knowingly, or recklessly. And the pattern jury instruction, at least the present pattern jury instruction, reflects some rulings that have come down over the years in Fain, in Briggs, and in Watkins, in which both this court and the Tennessee Supreme Court have taken up this issue and have all held that instructing the jury as to the charge of possessing a firearm during the commission of a dangerous felony can only be accomplished by an intentional mens rea.
How can I be ineffective if I don't object to the trial court giving at what is at the time the pattern instruction?
And that's a very good question, Judge. That is, of course, the state's argument on appeal, and they cite to some non-reported cases that hold that if you rely upon the pattern jury instruction, that you are not being objectively unreasonable. My position with respect to that, though, is you need not look any further than the offense itself to know that charging anything less than intentional isn't encompassed by the crime, because the crime itself is possessing a firearm with the intent to go armed during the commission of or attempt to commit a dangerous felony. So I suppose back in 2012, 2013, when the offense was allegedly committed, and then when this case was tried, the statute was also convoluted because it combined, from what I recollect at least, both possessing and employing a firearm during the commission of an offense. It's still a little bit unclear as to employment of a firearm, what the proper mens rea is. But as far as the possessing charge goes, it's my understanding that the statute has always reflected that one must intend to possess the firearm. And
well, I get your argument, but the standard I'm looking at is whether or not trial courts handled this below a reasonableness standard. And if there's a pattern instruction that everyone is giving that's, been approved, how is that below a reasonableness standard for that trial attorney to not object to what is a pattern instruction? Yes, it may change. Supreme Court may change the law on a lot of things, but at the time, that was the quote unquote law. That was the pattern instruction. How is he fallen below the standard at that point?
And as an officer of the court, I understand that is what several cases hold. That.
Well, let me ask you a different way. Do you have a case that holds that it is below the standard of reasonableness?
I do not.
Okay.
All I can really say as to the issue, and I understand that there are several cases that do not support my position. But what I could say with respect to this is you just got to look at the crime itself. And if the crime itself specifically says that one must intend to possess the firearm during that dangerous felony, even if the pattern jury instruction says otherwise, it at least could have been challenged, and it obviously wasn't. Okay. While acknowledging that there is case law that is contrary to the position I'm taking.
Mr. White, if you want to keep your rebuttal time, you need to pretty much conclude your argument. You can use some of your rebuttal time, of course, if you want to.
Judge, I'll reserve the remainder of my rebuttal time. Thank you.
Certainly. Good morning, General Simpson. Are you ready to proceed for the state?
I am, Your Honor, and good morning. May it please the court, Samantha Simpson on behalf of the state of Tennessee. Your Honors, this court should affirm the post-conviction court's denial of relief because the petitioner has failed to establish that in all of the factual grounds that he has alleged, he's failed to establish both prongs of the Strickland standard. And I'll go ahead and jump in and address the stipulation issue. And Judge Dyer, to address your question to defense counsel, the trial court did instruct the jury on stipulations, but this stipulation regarding the petitioner's felon status was not included in that instruction. There are 4 portions of that stipulation, and that's also found in the direct appeal record. And there was a formal written stipulation also in the technical record. And all of those stipulations involve the school zone aspect of the felonies and where the marijuana was located and the location of Culleoka Unit School. So as far as
so let me see if I understand then. There may have been a stipulation between counsel and the state about his status as a convicted felon, but that actual piece of paper, so to speak, was never introduced to trial. Is that what you're saying?
As far as my review of the direct appeal record, that is correct, Your Honor. I went back and looked.
So the only thing we have, back to the question I asked defense counsel, is a single statement by a police officer in response to a direct question, but still a single statement by a police officer. Is the defendant a convicted felon? Yes.
Correct, Your Honor. During Agent Doley's direct testimony, the prosecutor asked Did you run a background check on the petitioner? He answered yes. And what did you find out whether he was a convicted felon? And the officer answered yes. And that was it. So literally 2 questions and 2 responses. So here, the petitioner simply cannot establish that he was prejudiced by this stipulation. And contrary to defense counsel's assertions, the proof here was strong. The Tennessee Supreme Court affirmed the sufficiency as to all of his convictions. There was significant proof that the petitioner was involved with the conspiracy to possess and sell marijuana, including the fact that the petitioner possessed 8 pounds of marijuana in his residence that was packaged similarly to the marijuana at the son's house in Mount Juliet. So again, to address the stipulation, the petitioner cannot establish that defense counsel was that it was prejudicial to the effect that it would have affected the jury's verdict. And to briefly address some of the cases that defense counsel brought up in his argument and in his brief, Griffin and Faust and Old Chief and some of the other cases that he cited, even taking them out of the context that they were direct appeals and considering them in the post-conviction context, they were factually different from what we have here. Again, as Judge Dyer noted, the only evidence that came in was that he was a convicted felon. The nature of those convictions, the jury never heard. So on that basis alone, they can be distinguished, or this case can be distinguished from the cases that the petitioner cites to, as far as the bifurcation. Next, the petitioner argues that conspiracy to possess with the intent to sell is not a dangerous felony, but this is simply not supported by a plain language interpretation of the statute. Here in count 4, again, the petitioner was charged with possessing a firearm with the intent to go armed during the commission of a dangerous felony. And the state elected that the predicate dangerous felony was his conviction or his charge for conspiracy to possess 300 or more pounds of marijuana with the intent to sell. And defense counsel referenced in his testimony that he did not challenge the indictment because of the language in the predicate felony, the dangerous felony statute that says involving. And to quote the statute, it says a felony involving the sale, manufacture, distribution, or possession with intent to sell, manufacture, or distribute a controlled substance. And the post-conviction court reasonably looked at that statute and determined that the word involving is broad enough to include a inchoate offense such as conspiracy. And for the same reason, defense counsel reasonably did not challenge the language of the indictment. And for the same reason, the conviction is not void. There is no reported cases interpreting this statute any other way. So again, all the current interpretation, as far as this case has been experiencing, involving is broad enough to include conspiracy. Thus, the petitioner cannot establish both of the Strickland prongs in that allegation. Next, the petitioner claims that defense counsel should have objected to the pattern jury instruction regarding the possession of a firearm with the intent to go armed during the commission of or attempt to commit a dangerous felony. And the trial court instructed and gave the instruction of the Tennessee pattern jury instruction number 36.06C. And at that time, when this case was tried in 2013, Fane had not been decided by the Tennessee Supreme Court. And this court had not issued its decisions in Tasha Briggs and George P. Watkins. So defense counsel reasonably relied on and did not object to the trial court's usage of the standard pattern jury instruction that was used at this time. Now, with the benefit of hindsight and with these cases that this honorable court and the Tennessee Supreme Court has issued, it would be unreasonable for a defense counsel not to object to an instruction using the general mens rea. But at that time, it was standard for trial courts to use that instruction, and thus the defendant cannot establish that it was unreasonable for defense counsel to have objected on this ground. The next argument is that defense counsel should have requested lesser included offenses in the jury instructions by weight, and I believe also by ask for facilitation. And here the petitioner cannot establish his allegation because defense counsel testified at numerous points during the hearing that this was a strategic decision not to request lesser included offenses. Defense counsel recalled that he spoke with the petitioner, and during that discussion, defense counsel talked with the petitioner and said, look, if we ask for lesser included offenses, even if you get convicted of a lesser included, you're still going to essentially receive a life sentence because of the petitioner's age and because of his prior felony background. So based on his conversation with the petitioner, defense counsel came up with a strategy, and he decided to not ask for these lesser included offenses to be instructed because he wanted the jury to either convict of the charge of offense or fully acquit. He did not want to give the jury the opportunity to come to a compromise verdict on a lesser included offense, which essentially would have landed the petitioner in the same position of an extensive jail sentence. And that was a reasonable strategy, and this court should defer to that strategy. Next, defense counsel argues that, or petitioner argues that defense counsel should have raised a double jeopardy claim. And based on the money laundering statute, defense counsel testified that he did file a motion to dismiss. And he mentioned double jeopardy in that motion, but he did not seriously pursue it because he knew, based on this language of the money laundering statute, that it was broad enough to encompass the petitioner's action of hiding money in the trunk of his car. He specifically, the petitioner told Agent Breedlove that a year before the search at issue in this case occurred, he moved money from an ammo can to the trunk of his Honda Civic. So the state here indicted for that action of hiding the money. The state was not indicting the petitioner for any actions taken back in the early 2000s, for which were the basis of, I believe, his federal convictions. So here, the post-conviction court reasonably determined that the petitioner's actions were covered by the money laundering statute and that the buried money had not been found when the petitioner was previously charged with money laundering back in the early 2000s. And here the jury made a factual determination that the pre-2000 bills were laundered during the indictment period. And as I stated, the Tennessee Supreme Court affirmed the sufficiency of that conviction. Thus, defense counsel was not deficient for choosing not to challenge the money laundering charges and convictions on the basis of double jeopardy. Finally, the petitioner argues that defense counsel was deficient for not objecting to the Tennessee Supreme Court on the grounds that the state had waived its argument on appeal. And the petitioner is not entitled to relief on this ground because the Tennessee Supreme Court, it is within the scope of that court's power as the Supreme Court of the state to consider issues not raised by either party. And that's coming from the United States Supreme Court case of Kamen versus Kemper Financial Services Incorporated. And the United States Supreme Court has also said parties are not limited to the precise arguments that they made below. And additionally, the petitioner cannot establish prejudice because the trial court and this court in its decision were bound to follow the current Supreme Court precedent of Jackman. So even if the defense counsel had argued waiver in the Rule 11 application, petitioner's response to the state's Rule 11 application, or in his brief to the Tennessee Supreme Court, the Tennessee Supreme Court decided the issues that it wanted to review and was totally within its authority to overrule Jackman and reverse this court's decision and reinstate those convictions. And even defense counsel noted in his testimony that the defense bar was aware that the Tennessee Supreme Court was looking for a case to address the Jackman standard. And he said the Tennessee Supreme Court, they made no secret of it. So here it was reasonable for defense counsel not to object and raise some sort of waiver argument. And the petitioner also cannot establish prejudice on this ground. And unless this court has any further questions, the state respectfully requests that this court affirm the post-conviction court's denial of relief. Thank you.
Thank you, General Simpson. Mr. White, rebuttal.
First, Judge Dyer, to go back to an issue that was raised relative to a written stipulation. I went back and looked at the technical record very, very briefly during Ms. Simpson's argument, and I did not see a written stipulation in the technical record. And so I was incorrect in thinking that there was a written stipulation. I did not see that there actually was. And so I want to make that clear that it does not appear there is a written stipulation. Just simply a stipulation amongst the attorneys, I suppose, that there would be those questions asked, and that's what happened. So I want to make that clear that I was incorrect when I said that. With respect to the conspiracy to sell marijuana being a qualifying predicate felony, I simply disagree with the state's argument that the word involving makes the statute broad enough to include a separate inchoate offense that isn't listed within the statute. Let me. I pulled the book out and let me read this to you as I read it. If I were doing this, it is an offense to employ a firearm during, and then commission of a dangerous felony. So I'm gonna turn my page here. Here's what a dangerous felony is, and L says, a felony involving the sale, manufacture, distribution, possession with intent to sell, manufacture, distribute, controlled substance, blah, blah, blah. Okay. So it is an offense to employ a firearm during the commission of a dangerous felony, which is a felony involving the sale of drugs. Right. Conspiracy to sell drugs is a felony involving the sale of drugs. I disagree simply because the legislature specifically chose to include a separate inchoate offense of attempt under subsection M underneath L. And if they specifically chose to include attempt as a separate inchoate offense to encompass an attempt to sell drugs, it's my position that they could have necessarily included conspiracy under N.
Here's where to me, maybe it's confusion in the statute or lack of clarity in the statute, but your argument seems to have a problem because the first two dangerous felonies are attempt in the statute. So, and there's no such thing as an attempt to attempt. So to me, I get it. They're trying to use a catch-all at M, but at the same time, conspiracy to commit any of these crimes seems to fall in because it would be a felony. Conspiracy to sell drugs is a felony involving the sale of drugs. Is it not?
Well, I guess not in this instance, but a conspiracy.
Well, no, it either is or it's not. I mean, if conspiracy to sell drugs is either a felony to sell drugs or it's some sort of other crime that doesn't involve the sale of drugs.
Well, it could be a misdemeanor because you could conspire to sell or conspiracy to possess more than half an ounce of marijuana. But
okay, conspiracy to sell a felony weight of drugs is a crime involving a felony weight of drugs.
Well, I suppose that it could be, but the problem though is conspiracy doesn't involve actually selling it or actually distributing it, because that there could be an agreement, there could be one overt act in furtherance of it.
But it doesn't say that you actually have to sell the drugs. It just says a felony involving the sale of drugs.
Well, and I think as far as that issue of statutory construction goes, if there's a deficiency in the statute relative to, involving what that means, if there is a deficiency in that regard, the deficiency should be construed in favor of Mr. Tuttle.
But the only way that we find deficiencies is if the statute is ambiguous. Well, involving is not an ambiguous term. It's a plain ordinary day term. There's nothing to me ambiguous about a felony involving the sale or manufacturing of drugs. There's no ambiguity there. So it's the plain reading and meaning of the statute, and words have meaning, and involving means you're involved in it. Conspiracy is you're involved in it. They're almost synonymous.
I just simply disagree, Judge. I think to conspire to do it is different than actually doing it. And there's a reason for that, because most of the time the legislature drops the grading of conspiracy one level than if you had actually done it most of the time. And I don't know that we'll ultimately agree, but I do think it's different. And I do think if the legislature, if that's what they intended, they should have included it as a separate and code offense alongside attempt.
Right, I've stolen your rebuttal. Feel free to finish up. I'm sorry.
Just a couple more issues, and then I'll submit it to the court. With respect to the lesser included offense argument, basically the state is arguing that it was essentially a defense strategy to not request lesser included offenses because they were gunning for an acquittal. Obviously, Mr. Tuttle is advanced in age and he didn't want to die in prison. So he's hopeful for either an acquittal or he knows he's going to die in prison. The state relies on Goad and Hellard as support for that. I went back and looked at those two cases. I don't see that those two cases specifically stand for the proposition in this limited context. They do stand for the proposition that you're normally supposed to defer to a reasonable trial strategy. They do say that. But what I would submit to the court is that's not a reasonable trial strategy, because had the proper weights been listed, including facilitation as well, he could have in theory been convicted of conspiracy to possess greater than half an ounce but less than 10 pounds, because there were 8 pounds found in his house. The post-conviction court's analysis doesn't address, and the state's brief doesn't address the further part of this, which is the analysis in Moore, and then Moore talks about analyses in Williams and in Allen. Allen would be applicable here. Neither the post-conviction court nor the state in its brief addresses Allen and how Allen should have been utilized in this instance to determine whether there was an ineffective assistance issue with respect to the jury instructions. And then finally, the double jeopardy and money laundering issues. The biggest issue I see there, and there's two different issues in the brief that relate to this, but it's kind of a chicken and the egg issue, which came first. And obviously with the money laundering charge, the statute of limitations was 12/13 or maybe 12/3 of 2004. It's undisputed in the proof that we're talking about pre-2000 money that was so old and had been out in the weather so long that the rubber bands on the money had melted onto the money. That's the money we're talking about. And the money that's in question that's being laundered must be derived from a specified unlawful activity that happened on or after December of 2004. How could it possibly be that money that's pre-2000 with the rubber bands melted onto it was derived from the sale of marijuana that happened on or after December of 2004? That's impossible. I would submit that trial counsel should have challenged that under both double jeopardy grounds And then finally, just common sense grounds, that a reasonable probability of that being the case is the statistical probability of that happening is astronomical. And so ultimately, I'll submit the rest of the issues to the court, and we would ask for the court to grant Mr. Tuttle post-conviction relief for the reasons stated in the brief and here.
All right. Thank you. Let me compliment both of the attorneys for, obviously, you were well prepared. You made very clear and good arguments. And Mr. White, three things. Are you appointed in this case?
Judge, I'm representing the public defender's office through this.
Okay. All right. We appreciate the work that you do to help us get these cases resolved. Actually, my other two things have just escaped me. So, no, one of them was just, I wanted to tell you, I remember them both now, unfortunately, for all of you. One of them was to please, that we appreciate, or at least I do, when a lawyer is in front of this court and is willing to point out, where the law may not be totally on your side on something, and then go ahead and argue the points where you might prevail. But we appreciate that type of candor, at least I do, and so thank you. And my third thing was sort of another attempt at humor, and that is with this issue about involving. What does it mean? Despite your interactions with my esteemed colleague, Judge Dyer, you should never give up hope, because there's always a chance that Judge Ayers and I might disagree with Judge Dyer on that. And it takes a 2-to-1 vote to have an outcome. So appreciate your work and your argument on this case. In general, Simpson, as always, excellent work, briefs and arguments. So thank you. Thank both of you. All right. I think we're through with this case, and we'll be in recess pending the next case. Madam Clerk, thank you.
This Honorable Court of Tennessee is now in recess.